50 weirdest inheritance laws that still affect American families. Inheritance sounds simple. Someone passes away, their belongings go to loved ones, and life moves on. But dive even slightly into the legal archives of the United States, and you'll discover a world far stranger than any family drama. A maze of outdated, contradictory, shockingly specific inheritance laws that still linger in the system like forgotten ghosts haunting modern families. These laws weren't written by calm, rational committees. No, they were forged in moments of panic, jealousy, moral confusion, or pure administrative exhaustion. Somewhere in history, a wealthy individual left their fortune to a dog, so an entire state rewrote its statutes. Somewhere else, a family fought over a cursed acre of land, and lawmakers responded by banning certain types of heirs. And in multiple states, you'll find rules so bizarre, requiring witnesses for the reading of wills, forbidding certain relatives from inheriting, or granting assets to people who technically died earlier, that you have to wonder if legislators were drafting laws or simply losing bets. These laws still affect real families today. They determine who gets money, who gets property, who gets sentimental heirlooms, and sometimes who gets absolutely nothing because of a rule written in 1852. Today, we're opening the case file on the 50 weirdest inheritance laws that still affect American families. Inside, you'll find legal loopholes, historical relics, bureaucratic nightmares, conditional inheritances, and more chaos than any probate court should legally allow. Fasten your seatbelts. The strange logic of the afterlife and its paperwork begins now. 1. Pet trusts can receive millions, and they're 100% legal in the U.S. Every state now recognizes pet trusts, a legal tool that allows animals to inherit money through a trustee. These trusts can override human relatives if the will says so, leading to famous cases where dogs and cats received fortunes. Courts must honor these arrangements, even when angry family members insist the deceased must have been joking. When the law says your chihuahua deserves the money more than your nephew, the system has spoken. 2. The laughing heir rule still exists in many states. Under old inheritance doctrine, if someone dies without close relatives, distant family members, sometimes so distant they don't know the deceased existed, can legally inherit everything. About half of U.S. states still use versions of this rule. Some beneficiaries learn about their inheritance from genealogists hired to hunt them down. If a stranger celebrates your death, blame the statute, not the holiday spirit. 3. You can't inherit if you helped draft the will, a real protection rule. Most states prohibit a beneficiary from helping write or sign the will they benefit from. This rule exists to prevent undue influence, but families constantly break it unintentionally, especially when adult children assist elderly parents with documents. Courts often void gifts to these helpers automatically, even when everyone agrees no manipulation occurred. When helping with paperwork costs you the inheritance, bureaucracy wins the moral debate. 4th, stepchildren are not automatic heirs. Without a will, under probate law, stepchildren do not automatically inherit unless explicitly included in the will or legally adopted. This has resulted in countless disputes where close, beloved stepchildren receive nothing, while distant blood relatives inherit everything by default. Probate judges consistently warn families about this oversight. If your family tree includes a few asterisks, write a will before chaos writes itself. 5. Disinherited heirs can challenge lack of affection, an old Louisiana doctrine. Louisiana's civil law system retains unique rules that allow forced heirs, usually children, to claim inheritance if they believe they were unfairly excluded. Historically, courts examined behavior such as neglect or mistreatment, leading to emotional legal battles. While modern standards are narrower, the cultural residue remains. If your inheritance depends on proving emotional history in court, drama has entered its final form. 6. Per stirpes versus per capita distribution. Completely different outcomes. Most states divide inheritance using either per stirpes or per capita rules, and one phrase can drastically change who inherits. Under per stirpes, whole branches of the family get shares. Under per capita, only living descendants receive equal amounts. Families often don't understand these distinctions until after a dispute erupts. If your net worth depends on Latin grammar, you're living in a legal museum. 7. Outdated bloodline language can still exclude adopted children. Modern law protects adopted children, but some wills still contain old wording like heirs of the blood, which courts historically interpreted to exclude adoptees. Most judges now reconsider the intent, but disputes still happen when outdated documents surface. Lawyers call these accidental disinheritance cases. When a century-old phrase decides your fate, history becomes your strongest opponent. 8. Minors can inherit everything, but can't control a cent. Children can legally inherit massive estates, but courts require guardians or trustees to manage the money until adulthood. This sometimes results in kids technically worth millions while needing permission to buy snacks. Probate judges treat minors' accounts with extreme caution to prevent misuse. If you're rich but still can't stay up past 9 p.m., inheritance law is why. 9. Posthumous children have protected rights, even if born months later. Inheritance law protects children conceived before a parent's death, but born afterward. Many states allow a window of time for these children to qualify as heirs. This rule exists to prevent unborn children from unintentionally losing their inheritance because of timing. When you're eligible to inherit before you're eligible to breathe, the law bends space-time politely. 10. Estranged spouses may inherit everything if the divorce wasn't finalized. In many states, an incomplete divorce means the spouse is still considered the legal heir. Families routinely face situations where an ex-partner inherits property, insurance, and assets because of missed paperwork or a delayed signature. Courts follow the statute, even if everyone agrees the couple ended long ago. If your breakup depends on perfect clerical timing, romance isn't dead, the paperwork is. 11. The forced heirship rule in Louisiana still exists, but only for certain children. Louisiana's civil law system, inherited from France and Spain, still requires a portion of an estate to go to forced heirs, typically children under 24 or disabled adult children. This comes from centuries-old European inheritance philosophy that believed parents should never fully disinherit their offspring. As a result, wealthy Louisianans sometimes discover they legally cannot leave everything to a spouse or charity. When medieval fairness overrides personal wishes, the law becomes your family's co-parent. 12. The outdated dower and curtsy concepts still echo in modern law. Historically, married women, dower rights, and married men, curtsy rights, automatically received lifetime interests in each other's property. Most states abolished these doctrines, but some remnants still influence modern spousal inheritance. Attorneys must sometimes interpret whether old terms in wills activate these rights. If your marriage triggers vocabulary from the 1800s, probate court becomes a time machine. 13. Illegitimate children once had no rights. Some old wills still use the term. For centuries, children born outside marriage were excluded from inheritance entirely. Modern U.S. law now protects them, but many old wills discovered in probate still use the outdated phrase illegitimate issue, forcing courts to reinterpret intent. Cases often become emotional battles over archaic morality. When your existence must be legally redefined, the past refuses to stay buried. 14. Some states still have anti-lapse statutes based on 19th century family models. Anti-lapse laws prevent gifts in a will from failing if the intended heir dies first, but many of these laws still assume old-fashioned family structures. Some statutes only protect descendants of siblings, ignoring modern blended families. Courts must stretch interpretations to avoid absurd outcomes. If your inheritance depends on Victorian-era family charts, the law needs a software update. 15. Community property rules, a relic with modern power. In community property states, spouses automatically co-own most assets acquired during marriage, a concept rooted in Spanish colonial law. This can surprise modern couples who assume their earnings are separate. When one partner dies, ownership splits in ways that confuse families and fuel disputes. When 300-year-old Spanish law decides who owns your couch, history is incredibly persistent. 16. Spousal elective shares, a compromise between history and chaos. Elective share laws allow surviving spouses to claim a percentage of the estate, even if the will leaves them nothing. These rules evolved from ancient marital protections meant to stop husbands from abandoning wives financially. Today, they still overturn countless wills. If your final wishes can be vetoed by your spouse, marriage truly is forever. 17. Inheritance requires moral fitness. Old clauses still cause arguments. Some early 20th century wills contained clauses restricting inheritance to morally fit heirs, and courts occasionally must interpret these antique conditions. Families argue over what morality meant in 1910 versus today. Judges usually remove the clause, but only after emotional, theatrical hearings. If your character is judged by someone who's been dead for 100 years, justice is relative. 18. Certain states still mention male preference primogeniture in obsolete statutes. Although unconstitutional today, some states once had preference systems where eldest sons inherited more than daughters. While the rules are no longer enforceable, traces remain in historical statute books, confusing anyone reading the raw legal code. This outdated language occasionally resurfaces during litigation. When your legal rights depend on cleaning out ancient footnotes, gender meets paperwork. 19. Joint tenancy rules come from Old English feudal law. Modern Americans who hold property in joint tenancy with right of survivorship are unknowingly using a legal concept created for medieval knights. This rule allows co-owners to inherit automatically without probate, originally designed to avoid feudal taxes. Families today rely on it without realizing its origins. If your house deed is based on knight law, congratulations, your mortgage has feudal ancestry. 20. Some states still allow pretermitted heir claims based on old family assumptions. A pretermitted heir is a child unintentionally omitted from a will, and several states still grant them automatic rights. This rule assumes parents always want to provide for all children unless explicitly stated otherwise. The doctrine persists even when family dynamics are far more complicated. When the law assumes everyone loves everyone equally, reality laughs quietly. 21. A will can be rejected for using the wrong type of witnesses. Most states require wills to have 2 qualified witnesses, but qualified comes with a surprisingly strict definition. Beneficiaries, spouses of beneficiaries, minors, or anyone with a potential interest cannot legally witness the signing. Countless wills have been thrown out because a relative in the room looked too financially invested. If your future depends on who happened to be standing nearby, probate is a trust fall with paperwork. 22. Some states require self-proving affidavits, or the will becomes a puzzle. A self-proving affidavit is a notarized document attached to a will to confirm authenticity, and many states treat it as essential. Without it, courts may need to locate witnesses years later, often unsuccessfully. Probate lawyers joke that half their job is tracking down elderly witnesses who moved states and forgot the event entirely. If your inheritance hinges on someone remembering Tuesday from 12 years ago, good luck. 23. Digital wills are legal in some states, but only if signed with specific technology. A handful of states allow electronic wills, but the rules vary wildly. Some require video witnessing, some require encrypted storage, and some insist on electronic signatures that meet specific cybersecurity standards. One technical glitch can void the entire inheritance. When your final wishes crash like a corrupted file, technology becomes the grim reaper. 24. Estates can be frozen for months while courts verify assets. Probate courts often freeze estates until they confirm debts, taxes, and the authenticity of the will. During this time, heirs may be unable to access bank accounts, property, or even sentimental items. Families describe the process as waiting for permission to touch your own memories. If grief ends faster than the paperwork, welcome to probate. 25. Probate fees can eat inheritance, depending on county rules. Different counties have wildly different fee schedules for probate filings, certifications, and mandatory evaluations. In some cases, legal and administrative fees consume a substantial portion of the estate, even small ones. Families often feel like they're paying for the privilege of receiving their own property back. If inheriting money costs money, the system has opinions about your grief budget. 26. Some states require notice to creditors, even if the deceased had no debts. Many probate systems require heirs to publish legal notices inviting creditors to come forward. This rule comes from centuries-old anti-fraud tactics. Families sometimes pay hundreds of dollars to publish newspaper ads no one reads, just to fulfill a bureaucratic ritual. If the dead must advertise their financial history, the afterlife has admin fees. 27. Courts can demand an inventory of every object in the house. Some states require an exhaustive estate inventory. Every item, from real estate down to spoons, must be listed and valued. Attorneys have seen heirs argue over kitchen utensils because the law insisted everything be accounted for. If your inheritance hinges on cataloging teaspoons, bureaucracy is winning at comedy. 28. Certain states require a bond before you can manage the estate. Executors, the people responsible for distributing estates, often must post a bond unless explicitly waived by the will. This bond acts like insurance to prevent mismanagement, but it can be expensive and requires good credit. Heirs sometimes discover they can't administer a parent's estate because their credit score isn't good enough. If your financial past prevents you from handling your family's financial future, irony has entered the chat. 29. Handwritten wills, holographic wills, are valid, but only if they meet odd requirements. About half the states accept handwritten wills, but each has strict rules. Some require the entire will to be handwritten, some allow mixed formats, and some require specific wording. Courts constantly battle over whether a messy note found in a drawer is a heartfelt final wish or a grocery list. If your inheritance depends on handwriting analysis, welcome to forensic calligraphy. 30. Wills must be stored properly, or they can be presumed revoked. In many states, if the original will cannot be found and is presumed destroyed, courts assume the deceased intentionally revoked it, even if copies exist. Fires, misplaced documents, or disorganized filing cabinets have wiped out entire inheritance plans. If your legacy can be undone by a bad filing system, mortality isn't the problem, storage is. 31. The Slayer rule automatically disinherits murderers, even if the will says otherwise. Every U.S. state now enforces a version of the Slayer statute, which prevents someone from inheriting if they intentionally cause the death of the person whose estate they want. Courts once faced cases where killers argued they should still inherit because the will says so. Judges had to clarify that murder is not a valid estate plan. If your inheritance depends on not killing the person giving it to you, the bar is extremely low. 32. Some wills impose lifestyle conditions, and courts sometimes enforce them. Historically, some wills required heirs to meet strange conditions like maintaining a certain hairstyle, staying unmarried, avoiding alcohol, or even changing religion. Courts occasionally uphold these conditions if they don't violate public policy. Families have watched inheritances evaporate over haircuts and lifestyle choices. If your fortune depends on obeying someone who's already dead, congratulations, you're in a long-distance relationship with the afterlife. 33. Dead heirs can still inherit under certain statutes. Under some legal doctrines, an heir who dies shortly after the deceased may still be considered alive for inheritance purposes, depending on survival time requirements. This has created bizarre situations where assets pass to a person who is already dead, only to be redistributed to their heirs. When estates go to the dead so they can be passed to the living, the law is just playing financial ping pong. 34. Courts sometimes follow wills that leave money to future children that never exist. Many wills include clauses saying assets go to future children or grandchildren, even if none exist. If no such descendants ever appear, courts must apply complicated fallback rules, sometimes giving money to relatives the deceased didn't know. If your non-existent baby has legal rights, imagination is now part of probate. 35. Some states enforce survivorship minimums. Even 120 hours under the Uniform Probate Code, heirs must outlive the deceased by at least 120 hours to inherit. This rule was designed to prevent estates from passing back and forth during simultaneous deaths, like accidents or natural disasters. Families sometimes lose inheritance rights by mere minutes. If your legacy depends on outliving someone by 5 days, timing becomes destiny. 36. You can be barred from inheriting if you refuse to acknowledge paternity. Certain state-level doctrines allow courts to deny inheritance claims from biological fathers who abandoned or failed to support their children. The logic aims to prevent neglectful parents from benefiting financially later in life. Probate judges describe these rulings as retroactive parenting consequences. If being a bad dad costs you money decades later, karma finally hired legal counsel. 37. Some wills condition inheritance on marrying someone of a specific religion. Courts historically upheld wills requiring heirs to marry within a certain religion or denomination to receive assets, provided the condition wasn't discriminatory beyond religious lines. These cases still appear today in contentious family estates. If your marriage choices are judged by a ghost with strong opinions, romance has competition. 38. In certain cases, estranged children must prove they are actually related. When no formal documents exist, some states require DNA tests or detailed genealogical proof for estranged children to inherit. This leads to courtroom drama involving ancestry experts, old photos, and family legends. If your identity becomes a scientific experiment, inheritance law has entered the chat. 39. Some estates prohibit heirs from selling inherited land for 20 to 40 years. Certain old wills include restraints on alienation, limiting when heirs can sell inherited land. Courts enforce these clauses if they're deemed reasonable, resulting in heirs owning property they cannot use, improve, or sell. If your inheritance is a hostage situation with paperwork, the law is the kidnapper. 40. Judges can override wills if they consider them against public policy. Even if a will is clear, courts can invalidate clauses deemed immoral or harmful, such as requiring illegal behavior, encouraging divorce, or mandating cruel conditions. This gives judges the power to erase entire sections of a person's final wishes. If the law decides your last request is stupid, the afterlife still has an editor. 41. A will can require you to change your name, and courts sometimes enforce it. Certain inheritance conditions historically required heirs to adopt the family name to receive property, and courts have upheld such clauses if they weren't discriminatory. Multiple famous U.S. cases involved beneficiaries legally changing their last names to claim land, wealth, or historic estates. Judges view these conditions as annoying but not illegal. When your family fortune demands a rebrand, identity becomes negotiable. 42. Some wills require heirs to live in a specific house forever. Conditional inheritance can force heirs to occupy a property for a minimum number of years, or the estate is forfeited. These rules were originally meant to preserve family land, but in modern life, they feel like contractual imprisonment. People have inherited homes they can't afford, can't leave, and can't sell. If your inheritance comes with house arrest, the gift is the punishment. 43. A beneficiary can be disqualified for failure to survive, even by minutes. Many states require an heir to survive the decedent by a minimum statutory time, often 120 hours. If death certificates show the heir died even slightly earlier, the entire inheritance reroutes to backup heirs. Probate lawyers say it's the harshest game of who lived longer ever invented. When your legacy depends on a stopwatch, mortality becomes competitive sport. 44. Simultaneous death laws can decide everything, even when the timeline isn't clear. Simultaneous death statutes create legal fictions for cases where it's unclear who died first, often in accidents. Courts must assign inheritance based on probability rather than certainty. Families have watched estates legally pass to someone who likely died moments earlier. If your inheritance depends on a legal guess, time loses the argument. 45. Courts can enforce no marriage clauses in wills, if written carefully. Some wills restrict heirs from marrying certain people or marrying too soon, and courts sometimes enforce these conditions if they don't violate major rights. These clauses originate from old moral rules designed to guide family choices from beyond the grave. If a dead relative controls your love life, romance isn't dead, it's supervised. 46. You can inherit nothing if the will is stored wrong, because it's presumed destroyed. Across many states, if an original will is missing, courts presume the testator intentionally revoked it, even if everyone believes it was lost accidentally. Fires, moves, and messy file cabinets have erased entire estates. If your inheritance is killed by poor storage, the villain isn't fate, it's the filing drawer. 47. Negative bequests can disinherit someone explicitly, and courts honor it. A negative bequest means the will states who should not inherit, even if default law would normally give them a share. Modern courts uphold these exclusions as powerful expressions of intent. Families often discover these disinheritances during probate with shock and immediate whispering. When the will names you just to say you get nothing, the afterlife sent a message. 48. Heirs must sometimes refund what they already spent, if new debts surface. Probate law allows creditors to make claims after distributions if debts are discovered later. This means heirs may have to return assets even long after spending them. Lawyers call this inheritance boomerang. If your inheritance comes back like a debt-collecting ghost, the past isn't done with you. 49. A will can leave money to a non-human entity, as long as a trustee manages it. Courts have upheld wills leaving assets to gardens, statues, cemeteries, charities with barely formed structures, and even concepts like beautification funds. As long as a human trustee can manage it, the law allows it. When money goes to an object with no pulse, but not to you, the deceased had strong priorities. 50. Courts can ignore the entire will if it violates public policy, no matter what it says. Even the clearest will can be voided if it encourages illegal behavior, discrimination, cruelty, or social harm. Judges have wiped out wills that tried to control families too tightly or impose unethical conditions. Inheritance law ultimately bows to morality over personal wishes. When even your last request needs ethical approval, the afterlife has a review board. If you've made it through all 50 inheritance laws, congratulations! You've just toured one of the strangest intersections between human emotion and historical paperwork ever invented. Inheritance should be simple. Someone dies, their assets go to the right people, and everyone moves on. But as we've seen, reality is far less graceful. The American legal system is packed with ancient rules, bureaucratic puzzles, moral expectations, and loopholes so bizarre they feel like artifacts from another universe. We've seen pets outrank relatives, dead heirs inherit property, unborn children receive rights, and distant cousins appear out of nowhere like genealogical jump scares. We've watched courts enforce centuries-old doctrines, interpret cryptic Latin phrases, decode handwriting, investigate family legends, and occasionally play referee in conflicts that feel more like Greek tragedies than probate cases. And behind every rule lies a story, usually one involving a spectacular human mistake. Someone wrote a will badly. Someone hid it poorly. Someone created conditions too ridiculous to follow. Someone promised the wrong person too much. And lawmakers, panicked or exhausted, responded by creating a rule they assumed would fix everything. Instead, it outlived everyone involved. The strangest part? These laws still shape real families today. They decide who gets what, who gets nothing, and who unexpectedly becomes the owner of a house, a farm, a dog trust, or a problem no one wanted. Because if death reveals the truth about a person, inheritance reveals the truth about everyone else. Love may guide life, but paperwork rules the afterlife. And now that we've sifted through 50 of the strangest, most outdated, most unintentionally comedic inheritance laws still shaping American families, one undeniable truth rises to the surface. Death may end a life, but it never ends the paperwork. In fact, the paperwork often becomes louder than the people left behind. These 50 laws reveal something far more profound than legal oddities. They show how deeply humanity fears chaos and how badly we try to control what happens after we're gone. Laws were created to protect children, punish villains, preserve property, reward loyalty, prevent fraud, and occasionally enforce moral expectations written by people who sincerely believed they could guide the behavior of future generations from beyond the grave. Some rules are noble, some are absurd, some are embarrassingly outdated, and a few feel like the punchline to a joke nobody remembers telling. But the strangest pattern is this: every law exists because someone, somewhere, made a decision bizarre enough to force lawmakers to intervene. Someone left everything to a dog. Someone hid their will in a freezer. Someone married the wrong person too soon. Someone tried to inherit from a person they killed. Someone forgot to sign their will. Someone signed it in crayon. And someone desperately believed that by adding one more rule, future families would finally behave. They didn't. What inheritance law truly reveals is not how we die, but how we live, how we form relationships, hold grudges, ignore details, cling to objects, create meaning, pass burdens, and sometimes accidentally leave chaos behind. Probate courts are filled with stories of people trying to organize their final wishes and families trying to interpret them, while judges attempt to untangle the emotional knots left by generations. In a way, it's strangely comforting. It means human imperfection is universal. It means families everywhere struggle with the same things: identity, fairness, memory, resentment, loyalty, and the sheer unpredictability of life. It means even when someone is gone, their influence, or their paperwork, continues shaping the world. So as we close this file, remember, you cannot take anything with you. You cannot control everything after you're gone, but you can leave behind an organized will, or at least avoid writing something that forces a judge to say, "I can't believe this is legal, but technically, yes." This has been The Absurdist Files, where logic retires early and the law keeps working long after everyone else is gone.